All right, we'll call the next case Carter versus Commission on Ethics. Carter, hold off for just a minute and let counsel get...
Mr. Lindsay.
Oh, Mr. Lindsay, I'm sorry.
That's okay, Judge.
All right, sir.
Good morning. My name is Warren Lindsay. I represent Stephen Carter. Today, what we're asking the court to do is to reverse the Ethics Commission's order that Mr. Carter violated the statute that's enumerated, the 112.313, the Corrupt Act statute, by supposedly obtaining severance payment, contract cancellation agreement while remaining employed as general counsel for the Orange County Clerk or the Orange County Clerk of Court.
Mr. Lindsay?
Yes, sir.
You don't challenge the findings that are contained in the final order. You're simply challenging, assuming those findings have been proven and accepting those findings, they don't constitute a violation.
That is correct, Your Honor. That is correct as to the main issue about whether or not he should have been found to have violated the statute at all. As to the second issue about the $10,000 fine, actually the advocate made a challenge to that, but we agree. We're saying that exactly what, Judge, what you said, that even if you take all the findings of fact by the administrative law judge, in which the Ethics Commission found that it's not a violation of the statute, basically the uncontroverted facts that were found by the administrative law judge is that back in 2005, a contract, an employment contract, was entered into between Mr. Carter and the then Clerk of Court, Lydia Gardner. And I believe that a reading of the administrative law judge's order, the administrative law judge does not, there's no challenge or there's no statement or finding of fact in the administrative law judge's proposed order that there was anything wrong with that contract, that it was an okay contract, it was not an illegal contract. This was a contract that had not just been come into existence near the end of Lydia Gardner's term when she passed away, but it was something
Wasn't the intent of the contract, I mean, the intent of the contract and the remedy or the protection to Mr. Carter involved if he was terminated from his employment, correct?
It was, the way it was, great question, Judge. The way it was written was it didn't, the contract, if you look at it from 2005, the way it was written was it was not conditioned in any way upon him leaving. It was when the contract expired or when the contract was canceled, when it was canceled.
When he was terminated.
When he was terminated, correct, when he was terminated, not...
Against his will, he desired to stay and remain in employment, an employee of Mrs. Gardner, and he was terminated, apart from his will, correct?
Yes, that is correct. When he was terminated, it did not require, though, that the contract had to be terminated. But if you look at the contract clearly, the one from 2005, clearly says that it's a contract termination. It's not that he has to leave employment, but it's the contract termination is when the so-called severance kicks in.
So my concern is, and one of the paragraphs, paragraph 67 of the ALJ's findings included some colorful language about, having his cake and eating it too. But the underlying concern that I have was the facts that came out in front of the ALJ was that he was, at least one side of it is, he was seeking to have the termination effective, but he had no intention of vacating or leaving the job. That was at least the allegation, correct?
That was the allegation, Judge, because when he was terminated by the then appointed clerk, Colleen Riley, who had she was acting clerk, she had all the powers of the constitutional position of clerk. When he was terminated, I don't think that there was any expectation that he was going to be there very long. I think that it was assumed that the governor would make a appointment very promptly and then he would be gone quickly. As it turned out, he ended up being there, I think, about 9 more months. But I think that when Colleen Riley, the then clerk, terminated the agreement, the contract agreement, I think at that point it's clear that the expectation was that he was not going to be around very long.
She terminated not only Carter's, but she terminated her own.
That is correct.
And they both had the identical provision, correct?
They were a little bit different. The administrative law judge said in his order that they were the same, but in fact that they were a little bit different. I mean, his said that upon contract termination, or hers was a little bit different. But yes, she terminated her contract as well as his contract.
These are the same two people that met with the clerk, I mean, literally on her deathbed,
Yes.
to get her to terminate their employment.
To ask her to do that, which is, there's nothing, I understand what the court's saying. You could say that is something that doesn't look good.
It smells.
It smells, but that doesn't mean that it is corrupt or that it's wrong. I think that the evidence showed at the hearing that Mr. Carter and Miss Gardner had known each other for many, many years, that they knew each other prior to him becoming the general counsel or the clerk's counsel back in 2003, and he had been there a long time. So they had a pre-existing relationship where they could talk about things.
This is an ethics issue. And we're not here to debate whether or not he was owed the money or not. That's already been handled in that respect. We're here to talk about the ethics of the circumstance, correct? And
Yes.
whether or not the findings were supported with regard to the commission.
That is correct.
So in any of this, and I'm asking, I don't know, but in any of this, was the fact that Mr. Carter was an attorney, did that play into any of this?
I don't think it would play into any of that. I mean,
The clerk just wasn't his employer, the clerk was his client.
That's true. But when they entered into the initial contract, which was in effect continued over the years, when they entered into that contract, there's no evidence other than that it was an arm's length. There was no impropriety, and nobody, the underlying contract, there was no finding, and to answer what you said, Your Honor, there was no finding by the administrative law judge that there was anything wrong with that contract. There was testimony at the hearing that raised issues about, whether the policy, 25% of sick leave, or as a policy, not a state statute, but ultimately, the administrative law judge did not find that there was anything wrong with the entry into the contract.
I agree with you. The findings weren't based on the fact that there was a provision in the contract. The findings were based on the circumstance of getting paid for a termination that never happened, or
That is
wasn't
correct.
intended to be happened. So let me ask you this, because I know you run a law practice. You have for almost, 40 years you've run your own
Quite.
practice. Like all of us, you've had the misfortune of having to hire and terminate employees. When you terminate an employee, usually there's something that goes along with that you get their keys back, they have to surrender their code ring, or whatever. Is there any evidence that any of that happened in this case?
Not when he finally left, there was, but at the time of the termination of the contract, no, because he stayed on. So there was nothing like that occurred because he stayed on.
So how do we get to argue that he, in good faith, was asking for severance, understanding he was going to remain working exactly as he had before? I mean, again, we talked about the smell test. How does that pass the smell test?
Well, I mean, I think whether it passes a smell test is not the issue. The issue is whether or not it was legally okay. And Colleen Riley had the authority to cancel the contract, to terminate the contract. Nobody is challenging that she did. So a lot of times in contractual situations, things don't pass a smell test. They look like, maybe they could have been done a different way, or from an optics standpoint is what the court, I think, is talking about, and what Judge Wallace had talked about. And so, yes, I think that it didn't pass those tests, but I don't think that is the operative analysis as to whether or not the statute was complied with whether or not under the situation here that there was any kind of corrupt intent or anything like that. I think you had a long-standing contract, and I think the way to look at it is different than, whether or not they look about all the smell stuff and the optics. It's whether or not the contract was valid, and there's no question that it was, the employment contract, and whether or not Colleen Riley, who was a clerk of court, whether or not she had the authority to cancel it, and whether or not Colleen Riley had the authority to construe it the way it was construed. And I think that those are...
Lawyer for construing was Mr. Carter, correct?
Well, Colleen Riley is ultimately the client, and she construed it that way.
Is there any findings that Carter and Riley either conspired together, planned together, executed together the strategy by which she would terminate both of their employments, which she did, by the way? Both would then qualify for their severance pay, and both would actually remain at their job, for the foreseeable future.
I think that there was evidence that they talked about the what was going to happen to them, as anyone would, if the clerk passed away. I think that there was definitely evidence that they did that, but I don't think that there's anything corrupt or wrong with that. Those are normal types of things. And I think Colleen Riley did not testify. There was no testimony by her. But the testimony before the administrative law judge was unrebutted that she did not, that she agreed with this, that he was in effect implementing her directives to do what she said to do. And so if she's doing that, even as the court points out that the optics look bad, it doesn't make it wrong, it doesn't make it illegal.
It does if he advised her to do that and was complicit in that, in light of the fact that it's double dealing. He's personally benefiting from essentially a fraud. I mean, he's getting severance pay as if his contract is terminated, and talking his employer, Ms. Riley at that time, into terminate him, at the same time agreeing with Ms. Riley that they're both going to stay on indefinitely. Isn't that a fair reading of what the...
I think I see what the court's saying, but I don't think that there's anything that's improper about that. If Colleen Riley agreed with it, if she had the authority, that even if someone looking from the outside believes that it, like you said, doesn't pass the smell test. The smell test is not the test to ascertain whether or not something is corrupt or improper under the statute. So if she has the authority and she orders it and she makes a decision that she doesn't want to seek other counsel or whatever, that's her decision, and as a client she has the right to make that decision, I believe.
Mr. Lindsay, let me ask you about the findings that the ALJ made regarding the method by which this was implemented. Apparently, the decision is made to terminate the contract, and instead of going through what they call the talent management group, the normal way an employee would process out of the organization, I think it's fair to say that he shortcuts that, and that some of the employees felt uncomfortable with that Ms. Riley gets involved, and there's these powwows and questions about loyalty. Do those findings in and of themselves, the ones where he goes outside the normal chain of command that he apparently asked for and initially got adjustments to his payout that seem to be outside the normal, the way you get paid for accrued time that hasn't been used, that are outside the normal things, wouldn't those things in and of themselves be sufficient basis to find an ethics violation?
No, Your Honor, because first of all, this was not a normal situation. There was no evidence other than the only two people. There was nothing presented as to how many people worked at the clerk's office, but we can presume that there was well over 100, maybe more, maybe several hundred. But the only two people in the clerk's office that had contracts were Mr. Carter and Colleen Riley. So there was nothing. So of course, anything regarding the implementation of those contracts would be out of the normal course of the way things were done, because they were treated differently by Lydia Gardner from the beginning. But second, if Colleen Riley is a clerk, there was no evidence that any of those so-called procedures that the court has talked about were in writing. They were just normal course or customary course things. And Colleen Riley is the clerk, and the clerk has the authority, the right to have implement any policy she wants. She can do it however she wants. If she wants to do it a different way for them, she's allowed to do it. So I think that I understand what the court's saying is that there was an effort below to make that seem somehow sinister or but it's not.
Handed.
Right, but there's nothing, if the clerk says, we're going to do it this way, when all this happened, Colleen Riley was a clerk. She had the authority. If someone that has the authority wants to do something different, wants to direct subordinates to use different procedures, different ways, that is completely okay. Maybe subordinates in going back to what Judge Perkins said about my law practice or something, of course, whenever something in any kind of a business community, a corporation or whatever, if someone does something that other people don't like and there's personalities involved and they take offense and things like that, which there was definitely evidence of, people felt like they were being that Mr. Carter was aggressive. That was one of the terms used. But there's nothing that doesn't in any way obviate the fact that the clerk had the authority to do it differently if she wanted to not follow protocols. And also with these particular two people, they are different from anybody else. They're the only ones that have employment contracts. So that's
The first payment outside of it was before the clerk actually stepped in and directed payment?
No, the payments were not made until after, the first payment was made after Colleen Riley was the appointed interim clerk. Is that what you're?
I know she was the appointed clerk, but at some point, she got directly involved.
Yes, she did.
With all of her employees that were making these decisions.
Correct.
And basically said, you're going to do it this way because I'm saying you're going to do it this way.
That is completely correct.
Challenged their loyalty or something, wanted to know something about their loyalty.
She did all that.
And directed that they were going to do this, and of course, she directly benefited. But I guess what I'm trying to get your explanation of, and I apologize for asking so many questions, but it's not that they had a severance package. It's not that the clerk was able to terminate the employment. It's that there's only two people with a severance. They're working together. They go outside of normal channels to get their payment. They tell the people that they're asking to make the payment, don't tell anybody about this. It's none of your business. Write the check. And all of that coming together, I don't think in the eyes of the administrative law judge and the findings that they made didn't pass the smell test. Why is that wrong?
Because you could have that situation, in any entity, any corporation, any
But
government.
isn't the difference between your law practice and the clerk's office, or your law practice and the court, is that they hold a public office, and they're subject to ethical requirements that the private sector might not be held to. And certainly you're free, within the bounds of the labor laws and all, to run your law office the way you want to. But the clerk isn't free to run the clerk's office the way he or she wants to. They are bound by the laws and the public trust. Isn't that really the problem here?
I agree with everything the court said, but again, that goes back to whether or not anything was done that the clerk, her being Colleen Riley, did not have the legal authority to do. If she did not have the legal authority to say, we're not going to follow the policy in this case, I would agree with the court. If she said that, if she didn't have, but she could do that. And so whether or not subordinates were offended because she wanted to do it a different way is not relevant as to whether or not she had the authority. If she didn't have the legal authority to do it, I would completely agree with.
Got a minute left.
Okay.
If you want to hold
Is
on
that for
to
my
it.
whole 20 or just the, okay, I'll hold it.
It goes by so fast when you're having a good time. If you'll just agree with everything he said, we can be done with this.
I wish I could, Your Honor, but I'm afraid I can't. I'm sorry.
Thought you might say that.
Thank you. May it please the court, I'm Elizabeth.
How do you, I'm sorry,
Yes, sir.
tell us your name. I apologize.
I'm Elizabeth Miller, Assistant Attorney General on behalf of the Appalachee Florida Commission on Ethics.
Ms. Miller, counsel's argument is that what they did was legal. It may have been outside the ordinary course of business, but it was in compliance with the contract. And there's nothing inherently improper about terminating a contractual period of employment and transitioning to an at-will period of employment. How do you rebut that? What's your best argument to rebut that?
Thank you, Your Honor. In reference to the contract, the payment of severance was conditioned upon Carter leaving the job. He didn't leave the job. There was no break in service. In February of 2013, Carter had an amendment made with Lydia Gardner, the clerk at the time, to amend the contract to define termination. Carter wrote that definition, and that definition said that for the purposes of this contract, termination by the clerk includes the ending of the employment relationship for any reason other than the general counsel's voluntary resignation. The ending of the employment relationship. This employment relationship did not end. There was no intent for it to end, as is evidenced by the 56 hours that Carter kept in reserve for annual leave, and there was no break in service. Then he knew what the purpose of this contract was, as evidenced by an email that he wrote to Colleen Riley in May of 2013, specifically May 2nd, 2013. And I'm going to paraphrase a little bit because there's some grammatical errors in the particular email. But Carter writes to Riley, the purpose of the clause, and he's referring to the termination clause, the purpose of the clause was to make us whole in the event we were terminated. That is, that we would have received following 6 months, we had still been under the contract. So he knew that the termination required him to leave if he wanted to get severance. That's what the contract said. That's not what he did. Now, they claim that this order of the clerk that made it all legal. And if that were true, it would still not obviate a violation under the Florida Code of Ethics for Mr. Carter, who was a public employee. As a public employee, he still owed a duty or was bound by the Code of Ethics to not seek a special benefit for himself in a corrupt manner. As this court is well aware, an attorney-client relationship is much different from a superior-subordinate relationship. As general counsel, Carter had an obligation to protect and preserve his client, that would be the clerk's office and Miss Riley. He had a duty to protect their legitimate interests within the bounds of the law. He had a duty to exercise his independent judgment in providing candid advice. He did not do that. But this much is what we do know. Carter was not an innocent, subordinate employee. He was the general counsel for the clerk's office. It was his duty to his client to avoid situations that created ethical breaches. He did not do that. It was not his duty to go blindly into whatever his client wanted him to do. That excuse may be a little bit more believable had Mr. Carter not been self-dealing, but he was. As far as the penalty goes, the commission correctly increased the penalty from what the recommended order was for public censure and reprimand. The commission increased it by $10,000. The commission, before it did that, reviewed the complete record, stated with particularity the agency's reasons for increasing the recommended penalty, and cited specifically to the record for its actions in doing so. Although hearing officers, as you know, are entitled to deference, it is up to the administrative commission or the administrative board to develop policy concerning the penalties that they impose within their areas. The agency needs only one reason that is supported by the record to increase the penalty. In this case, there were at least 6 compelling reasons for increasing the penalty to $10,000. First is the degree of Carter's scienter. His actions involved fraud, deceit, and manipulation. He used clandestine means to secure this severance payout to which he knew he was not entitled, including requiring secrecy from the employees who questioned it, circumventing the established office process and office policies, and avoiding the creation of any record of the transactions that occurred. The second reason is the substantial risk to the other persons. Carter had a callous indifference to the subordinate employees to whom he demanded pay him this money. In effect, he potentially put their jobs in jeopardy by asking them to violate office policies that they knew they had no business contradicting. The third reason for increasing the penalty to $10,000 is Carter's egregious conduct. This was purely a financial windfall for him. And also he helped Colleen Riley get a financial windfall of over $100,000 each in taxpayer money. This was not their money to divide up. It was the taxpayers' money. The fourth reason is that Carter's conduct was recurrent. It was not just a single episode. When Mr. Carter did not like the $58,400 that he got, he went back and sought that the whole matter be recalculated so that he walked away with $156,443.11. The fifth reason is a policy reason, and that's the policy, the public policy of deterrence. A civil penalty is necessary in this case for deterrence. A legitimate purpose in imposing the penalty is to lower the incentive of other public officials who may be considering committing this same ethics violation or to avoid misconduct.
So your argument is giving the money back isn't enough?
That's correct, Your Honor. And another reason, especially on that point, is consistency with other cases that are similar. The Commission has adjudicated other cases involving attorneys who have received money, ill-gotten money. And in those cases, a penalty was established, was recommended, and ordered. And this would also be in accord with those cases. Having no penalty, a financial penalty in this case, with this amount of money would be inconsistent with the other cases adjudicated by the Commission. As far as Mr. Carter, he is a public employee. He used and attempted to use his public position and his property within his resources, or property within his trust, or performed his official duties to get a special benefit for himself. And he did that with a wrongful intent. That is inconsistent with the performance of his public duties. He violated section 112.313, subsection 6. That's misuse of official position. Carter's contract obligated him to perform his public duties as general counsel in a competent and professional manner. As the attorney for the clerk, it was incumbent upon him to perform his professional duties, to make inquiries so as to be clear about what authority he had or they had, and to be clear what his legal opinion was on the subject. As the attorney for the clerk, Carter's attempt to shift responsibility and blame for his wrongdoing to Colleen Riley, who was his client, does not exemplify the high ethical standards Florida expects and imposes upon its public employees in the performance of their public duties. I would ask on behalf of the Commission on Ethics that you affirm the final order below. Thank you, Your Honors.
Thank you, ma'am.
Thank you.
Counsel, you got about a minute.
Okay. How much, Judge?
minute?
Okay, very briefly, the condition of the agreement was not that he necessarily had to leave employment. That was one of the definitions, but it was absolutely not. He did not have to do that to trigger the severance. But real quickly on point 2, I agree that the commission is allowed to increase penalty if they have a valid reason, but they have to have a valid reason. It has to be something that is in the findings of the administrative hearing officer, and there were many of the reasons were not valid reasons. One of the reasons is the commission struck the exceptions and yet used the exceptions, the fact that he merely challenged the process as an aggravator. There was no finding by the administrative law judge also that he placed any employees in jeopardy of losing their job, and the hyperbole of harassing and intimidating, coercing, or you'll find that nowhere, those words, that hyperbole, in the administrative law judge's order. Thank you.
Thank you, counsel. Thank you both. Have a safe trip home, and that will conclude oral arguments for this morning, so we'll be in recess.